Welcome to today's episode of Audit Austin Code Compliance. The gentleman you see here is named Michale Lynn Dial. He is a code investigator, not an inspector. It's one level up from the three levels of inspectors we have for the Austin Code Compliance Department. Mr. Dial is an employee of the City of Austin. We can see here at the City of Austin's database that Mr. Michale Lynn Dial is a code compliance investigator with the Code Compliance Department. He's a white male. He came to work for us on April the 25th of 2011. His base salary is $53,996.80 a year, so approximately $54,000 a year. When you look at the Code Compliance Department, there's Michale Lynn Dial here. He has his certifications, International Code Council certifications for property maintenance and housing inspector, as well as a zoning inspector. Although not required by the state of Texas, he is a registered code enforcement officer, which is a certification through the health department. He has held this rank since July the 21st of 2009. His license number is 4345 and it expires 7/31 of 17. Let's look at the job description for an Austin Code Compliance investigator. All of these things are available online. A lot of wordy things in here, but you can see that his position monitors a team of code compliance inspectors. And again, he's above code compliance inspectors. So there's a lot of generic job descriptions here on what he's supposed to do, but he serves as a field trainer and manages a field, the training field for operation personnel. So like any position, once you get proficient, you make a promotion and you start influencing how other people are trained and how they perform their job. Again, these are all available online, a high school diploma, 6 years of experience. He does have the ICC Council certifications for property maintenance and housing. And so all of his licenses and certifications appear to be up to speed. So here's another photo of Mr. Dial in his office. You can see that he's for all practical purposes, a lower level manager who helps teach other people their job. The Director of Code Compliance has been very adamant in the past about the training and the qualifications of his employees. In fact, Carl, what was it you said?
Yeah, our inspectors are some of the best trained, actually, as far as code enforcement officers in the state.
So let's take a quick look at the code compliance standards. This is a policy that is signed by Director Carl Smart, who you just met, and this is the guideline. This is the document that starts the education for an Austin Code employee. So, of course, you talk about the scope, a standardized public interaction for investigations and case documentation to ensure the city's ability to regulate Austin's codes equitably and to provide evidence and other information as needed for compliance cases. Pretty straightforward. The purpose of the policy is to establish the standards by which Code Compliance Department staff can provide quality customer service, accurately manage assigned cases, and conduct their duties in a safe and professional manner. The policy, CCD staff will follow the policies set forth in this document when conducting field investigations, interacting with customers, and managing cases. It also says, note, deviations of this policy must be approved by the Code Compliance Director or the Director's designee. So, again, Mr. Carl Smart has made it very clear this is the way he wants his people to conduct business. This is a 13-page document. We're going to go through it real quick. There's definitions in here. Direct communications is defined by phone, mail, email, or in-person dialogue. Initial site investigation is the first attempt to verify a violation or a condition on the property. Again, these are available through open records. Okay, here's a portion of the code compliance standards that talks about image and conduct of investigators. Mr. Smart is very clear that he wants his investigators should project a professional image and conduct themselves in a manner representative of a City of Austin public servant. The following steps will help achieve this goal. And so here they lay out how he wants inspectors to introduce themselves to the public. This is their first point of contact. This is going to set the tone for how the rest of the thing goes. So when an inspector or investigator statements of introduction and purpose, when meeting with individuals, investigators will announce their name, job title, and purpose for being there. My name is Michale Dial. I am a code compliance inspector with the City of Austin. And you hand them your business card. I am here to investigate a complaint concerning. So, when you first interact with the public, you're introducing yourself and you're telling them why you're there. The very first thing you should do. And again, the case logs are to document how step by step your investigation went, but it's also, in theory, something that you're going to take into court and tell the court about. So you have to be able to be very accurate, very honest about all of your actions. Communications with individuals responsible for correcting the actions. Make a diligent effort to obtain and document phone numbers, email addresses, and other relevant information. You can't guess. You want to return phone calls and emails within the next business day. The standards for investigating inspections. The following standards provide an acceptable minimum approach and methodology for determining whether or not code violations exist at a site, as well as a guide for monitoring inspections. Investigators will follow the standards described below in conjunction with violation guidelines throughout the course of their code compliance cases. So personal safety always first. Initial site investigations should be done within 2 business days of complaint intake. One of the first things they do is check the property for code violation from an approved vantage point. Attempt to make contact with the occupants by knocking on the door, ringing the doorbell, ensuring the person you are speaking to is the responsible party. If they're not there, you're supposed to leave a door hanger. If you're coming to my house, my business, you don't go out there and start walking around and doing an investigation and then wait for somebody to stumble across you and going, why are you on my property and who the hell are you? And so it's very clearly laid out in a very professional manner, but we're going to see, do they follow that policy? Standards for case documentation. The proper case documentation ensures the city's ability to adequately furnish evidence. Again, if you don't comply, if things go south, they're going to take you to court. This is where the pseudo law enforcement agency comes to play. And other information as needed for compliance cases. It's also vitally important to provide and maintain accurate and complete data to ensure consistent application of the codes enforced by Code Compliance Department and provide correct historical data when properties are subject to enforcement. So they talk about the photographs, taking views of your photographs, field notes, documentation in the case database case log. Documentation shall communicate sufficient information regarding the event being documented. It goes on to really reinforce all of these things. It says document all case activities in the appropriate database within 1 business day of the activity. They don't want you to wait 2 weeks and then add something in, because that can call into question your memory of the events that happen. The initial investigation findings always reference the particular code sections violated. Don't just say, well, they did this and they did that. You have to show the code references that were violated. So somebody is very clear of what you're being accused of. And more importantly, you can go and cross-reference the city code and figure that out for yourself as somebody who may be being investigated. Do not use the term owner or other titles without including the actual name of the person you talk to. Again, document permission to enter the property. This is commonly not done. And there are other things that go through here. So communication with individuals other than the complainants. This is policy. This is an expectation that phone communications, email communications, postal communications, office and site visit communications with individuals potentially responsible for violations, witnesses, and other persons shall be documented in the investigator's log. Okay? And so you can summarize it. It talks about it here. And again, phone messages are part of that. And this is an example of an acceptable documentation. Received an email with an email address from property owner Mr. John Doe requesting a 15-day extension. This is all part of the case log that accurately should reflect what happened. Doesn't happen. And we'll show you that in a few minutes. So that is the policy on how cases should be documented. Now let's take a look and see if they follow their own policy. If they truly are the best trained inspectors in the state of Texas. Okay, so this is what this is all about, an RV. This particular owner was contacted by the Austin Police Department unofficially and told that at a meeting that the officer went to with the Homeowners Association that somebody was going to start turning in RVs. So 4 months before the code department comes by, this homeowner puts up this screen in an attempt to try to screen his RV. Now the code says it has to be wood or masonry, says it has to be 6 foot tall, and so obviously you can't put a masonry fence up and pull your RV out. And so he erected this as his first attempt in order to comply. And then sure enough, a couple months later, somebody turned him into code compliance. Let's take a look at that first case log. Okay, here's the first case log from a code compliance. The case is from 2013, and here's the identifying number for it here. The current status is closed. It gives the address. It gives the property owner's name. The complaint date received on June the 17th of 2013. The complaint was an RV in side yard. Mr. Moses Rodriguez, an inspector with the Austin Code Department, was assigned on June the 17th. He was assigned the same day. Within 2 days, 2 business days, he's to come to the property and take a look. So let's see, did Mr. Moses Rodriguez follow policy? Here's his case log. On 6/20, he says he went to the property and observed an unscreened RV on the side of the house. There's no indication that he took any photos. There's no indication that he attempted to knock on the door or leave a door hanger for the property owner. Mr. Rodriguez's case log says 5 days later, he sent a notice of violation. And then 2 days after that, he decided to go by and leave his card on the door, but no one was home. No NE. It should be no one was home. And again, these are just being rubber stamped out. So here's the first problem. He should have gone by, looked at it, attempted to knock on the door. If nobody was home, he should have left a door hanger notice introducing himself, saying he's got a complaint, would you please call me, let's talk about this. He didn't do that. He drove by. We'll see that he took some photos. He went back to the office and he sent a notice, and then he left a note on the door. On the 28th, he says he did speak to Matthew Palmer, gives a phone number, wants a meeting next week concerning the screening of the RV. Okay? That's June 28th. By July the 3rd, it says we did meet with the property owner, we meaning somebody else, and that would be Jerry Reynolds, his supervisor, concerning the screening of the recreation. I did try to explain to him the fence he installed was not solid wood or masonry, that he would need to make it solid. He installed an ornamental fence about 6 feet tall. He said we were not interpreting the code right. He meaning Mr. Palmer, evidently. I told him he could seek a variance to get the interpretation. So again, Mr. Rodriguez did not cite the code. He doesn't say he handed the owner a copy of the code with exactly how it was supposed to be. So again, you start getting some misinterpretation going on here. This is July. And in September, evidently it's closed due to voluntary compliance. September the 6th, Moses Rodriguez went with Jerry Reynolds and they agreed on the screening. He did take photos. So let's take a look at his photos. So this looks like it's a very short and sweet. They came to a compromise. An investigator and a district manager by the name of Jerry Reynolds decided that, yep, everything is good, close the case. Here's the case photos from 6/20. You can see that this is the photo I showed you to begin with. Here's his case photos from 7/3. Again, now the homeowner's home, and you can see a different view. Their concern was that it was decorative and it wasn't solid. So they closed the case on September the 6th. These are the photos they agreed on. These are the photos he did. What they did was he had him put a piece of plywood on the back side. It is 6 foot in height. The bottom side was left open because there's no RV to be screened back here. It was an additional cost. The homeowner, the inspector, and the field manager all agreed that this would be an acceptable resolution to the case, and the case was closed with being in compliance. So the case was closed September the 6th of 2013. The homeowner, the inspector, and the district manager for code compliance worked through the issue and came to a resolve. The crotchety old guy in the neighborhood or somebody turns it in yet again. Now, here's where we start having problems. The complaint date was April 22nd, so we went from September 13 to April 22nd, 2014, and it gets turned in again. RV parked, not shielded by fence. Okay? This is April 22nd. Mr. Dial is assigned on May the 20th. Transferred to Michale Dial on May the 20th. Michale Dial, in this official case log, starts handling the case on May 20th. But look here, on April 24th, not May, April, May, June, April 24th, here's our first huge problem. Our timeline is off. Michale Dial, upon inspection, I observed an RV on the side of the house not screened. While taking photos, a white male came out of the house and confronted me in a very defense manner. I advised him who I was, and he advised me that the fence was down for repairs and that he would put it back up soon. I looked at the fencing that appears to be lattice. This young man cannot spell the word lattice. Look at the sentence. I looked at the fencing that appeared to be lattice, and that is when his attitude became worse. I advised I would do my research and respond accordingly. So the tone of the inspection got off to a very bad start because Michale Dial did not, after noticing the RV, did not go knock on the door and introduce himself and explain why he was there. He was taking photos when the homeowner came out. He should have introduced himself by policy, should have introduced himself and explained why he was there. Instead, the homeowner walks out after being through this in the past, and now he's got another city employee out there taking pictures of his property. Of course, he's going to be defensive. He's already been resolved. This has already been resolved. Instead of him saying, I introduced myself, gave him my business card, Mr. Dial says, I advised him of who I am, who I was. I advised him of who I was. Just a very poorly written statement. Okay, on the 25th, the very next day, Mr. Dial, follow-up inspection. I observed panels that only cover 2 feet from the bottom to the ground. The owner is very upset about this, as he was previously told the fence was okay. I advised him I'm working with my supervisor to determine if we're going to accept this fencing or proceed with the case. So again, Mr. Dial is not handling this very well. You've got a homeowner that has had resolve, and now it's being challenged again. And the gist of it is, Michale Dial told the homeowner, well, I don't care who Jerry Reynolds is, and that's not my supervisor. Jerry's been moved on, and my supervisor says we're going to do this. So on 4/25, again, this is the second day after Mr. Dial was on site. Mr. Dial speaks to his assistant division manager, Elaine Garrett, and to determine if it's a violation or not, as there is a note in a previous case stating that the fence panels are okay. So we know the next day after Michale Dial has done research, he sees that there's a previous case and it's been cleared. So it's very clear that Elaine Garrett, who is assistant division manager, who tried to reach the owner, could not reach the owner. Instead of waiting to figure out what's going on, she doesn't say that she talked to Jerry Reynolds. She's taken upon herself to talk to Michale Dial and told Michale Dial to send a notice of violation for a partially unscreened RV. Michale Dial says he sent that notice on 5/19/14. But is this a correct statement? Did he send a notice on 5/19/2014? Let's take a look at that notice. Here's the notice of violation sent to Matthew Palmer. It wasn't sent on 5/19. It was sent on 5/27, May the 27th. Mr. Dial lied in his case log. He said he sent a notice, but the notice was dated 8 days later. So when you look at the notice, the city is coming on strong and heavy. After you receive this notice, you may not sell, lease, or give away this property unless you have provided the buyer, leasing, or transfer copy of this notice. Again, they're trying to encumber his property. This is a blank form. He's suspected of violating the city codes. And here they're coming in strong. If you have any questions, please give us a call. Of course, they never return their phone calls. Failure to correct. Okay, so in this letter, they're telling him if it's not corrected, any existing site plan, permits, certificate of occupancy may be suspended or revoked by the city. If the site plan, permit, or certificate of occupancy is suspended or revoked, the utility service can be disconnected. If the violation continues, the city may take further legal action to prevent the unlawful action as unauthorized by the state of Texas. And so this thing is jumping off the bat, and you're accusing him of a crime, but they're telling him, if you don't fix this, we're going to come shut off your electricity. We're going to disconnect everything. And the fact is, they don't have the authority to do that. They have to take him to court first. If the violations are not brought into compliance within the time frames listed in the investigation report, criminal charges may be filed against you in the city of Austin, subjecting you to fines of $2,000 a day. This is not accurate either. This is all a bully tactic to try to get you to jump through the hoops and do what they think you should do. This is the investigation report. Items below listed, the city code. Summary, he does reference the city code here. Travel trailer not properly screened. But he doesn't really lay out what the code says. But he does give him a thing. He says he wants it done in 7 days. Okay? You can appeal a stop work order notice. Again, it wasn't a stop work order notice, but it gives him 3 days to appeal. This is how they bully you into doing things. So as I've just demonstrated, Michale Dial lied. He didn't send this on 5/19. He didn't send the corrective notice. Elaine Garrett received a phone call from Matthew Palmer regarding the case on his property. He wanted to know why the case is still open, that it's been closed back by a supervisor in 2013. She says that a new complaint came in and there was no screening at the time the inspector went out. They get into a talk about they're debating the code. Now, the homeowner was told everything is fine. Now, Elaine Garrett's interpreting the code a different way. The owner thought he had closure, and so now the fight starts. Michale Dial continues to go by this property time after time on 6/25, on 6/30, on 7/14, on 8/9. He is going by continuously taking photos of this thing. But on 7/14, he received an email from Leah Warner, who is an executive assistant for Carl Smart. She advised him not to take action until further notice. This finally reaches the attention of Carl Smart, and they're going, hey, wait a minute, back off on this. They know they have a problem. But Michale Dial continues to go out on 8/9, on 8/29, on 10/7. He's continually going by and doing follow-up inspections even after he's been advised not to take action. Now, it goes to a district manager, division manager, Paul Samolovic. I always mispronounce his name. We'll call him Tom, who advised to go ahead with enforcement on the case and advised him when the affidavit is filed. Okay, here it is. They're going after this guy. Even though they've given him a green light in the past, they decide they're going to sue him. They're going to take him to court. Melanie Alley is a paralegal who works for the city code department. She files affidavits. They take him to court. Okay? Michale Dial continues to go out there on a regular basis and take photos and harass the homeowner. The defendant's attorney appears in the office and requested a jury trial. Good for him. A motion for continuance was granted. The case is scheduled for jury trial January 15th, but it was reset. Again, Michale Dial is going out there and taking photos. Then they have a jury trial. The case is finally closed March 17th of 2015 due to judicial action. Okay? On February the 10th, a municipal court jury found the defendant not guilty of the October 7th, 2014 offense of failed to screen a recreational vehicle from public view. And it gives a number here. They finally get their ass whooped in court because a jury of the peers decided you can't flip-flop on this issue. Okay, so let's review the cast of characters. We've clearly demonstrated that Moses Rodriguez did not follow policy. He went by initially, he didn't talk to the homeowner, he didn't leave a door hanger, he didn't do anything. He took a couple photos, which he didn't log in his case log. He went back to the office, he sent a notice of violation. A couple days later, then he decides, I guess I better leave a note for this guy so he knows what's going on. Did not follow policy. Eventually, he goes on site with his supervisor, Jerry Reynolds. Jerry Reynolds, the only one so far who's got any sense, works with the homeowner. They come to a resolve and decide that if it's backed up with plywood, then the lattice is going to be fine. The bottom 2 feet, there's no RV exposed there, and they decide that it is closed due to compliance. Then comes along Michale Dial. This photo says it all. This is the professionalism of Michale Dial. Michale Dial, again, does not follow policy. Had he observed the RV, then he could have knocked on the door, introduced himself, and explained the situation, but instead, he decides he's going to start taking pictures. The owner comes out, of course, on the defensive. Why are you here? We've already done this. And Michale Dial just drops the ball and sets the tone for the rest of the investigation. He doesn't know what to do, so he contacts his supervisor, Elaine, who is a retired law enforcement officer and now a division manager. Instead of Elaine calling Jerry Reynolds and going, hey, why did you come to this conclusion? What are we going to do about this? Elaine decides, I'm in charge, and this is what the code says. I don't care what the other guy says. We're going to file charges. So, of course, she talks to Paul. Paul says, yep, that's what the code says. And, of course, Paul talks to Carl Smart, and Carl Smart is not a man of his word. You've seen that he thinks all of his people are the best trained, but I can prove time and time again, no, they're not. Instead of Carl Smart realizing that he empowered a division manager, Jerry Reynolds, the authority to make some decisions, and even though it might have been the wrong decision, it's one he should have lived with, he decides to take the homeowner to court. Why not? It's not Mr. Smart's money, it's the taxpayers' money. And of course, Carl Smart got his butt whooped in court. The homeowner was able to provide audio tapes, things like that, and a jury of Carl Smart's peers made the decision that Carl Smart cannot change his mind when the mood suits Carl Smart. So the big question is, does Carl Smart think this is funny? The homeowner had to spend thousands of dollars, lots of time, lots of anguish to go to court. He finally prevailed, but the fact of the matter is it wasn't Carl's money that was being spent, it was the taxpayers. And the sad part of it is, if you take the city of Austin to court, and even though you win, you still have to pay all the court costs. Nothing comes out of Carl's pocket, nothing comes out of Carl's budget. Carl Smart and other administrators and inspectors inside of the Code Compliance Department are abusing their authority, knowing that very few homeowners have the financial ability or the stamina to take them to court. They bully people into doing things they're not required to do by law. They create a channel whereby if you don't do this, they threaten you to have your electricity shut off, your certificate of occupancy yanked. This needs to stop. I'm calling to Mark Ott, our city manager, to put Mr. Smart to the curb. Strip him of his little gold stars, send him packing, and let's find somebody who will finally take all of our code employees, bring them back into the office, give them the recurrent training they so desperately need, and to hold them to the standards for which they are employed for. Carl, your days are numbered, sir. I hope you find a job doing something else other than code compliance, because you are not suited for this work.